Right now, we're going to look at one particular way that you, as an advocate, can build trust with the judge. It involves how you understand and interpret your role as an advocate and how you communicate as a result. Let's start by thinking about pressure, the pressure you feel as an advocate in court. There's pressure from your opponents, well, that's their job in an adversarial system. There's pressure from your client. If the dispute has come this far, the stakes are clearly high. And there's pressure from the judge who's trying to control proceedings and make difficult decisions. Of course, other people are under pressure too. You might not feel very concerned about them, you've got enough worries of your own. But really, you should spare them a thought, particularly the judge. There are 3 particular ways to help the judge. You can provide simplicity, which will reduce the strain and stress on the judge. You can offer clear and meticulous guidance on the law and procedure. This will help the judge comply with all their judicial duties. And you can help manage documents, which will help the judge to find the right document at the right time. We'll look at each in turn. When you open the facts of a case, think really carefully about how you do it economically. Just use those facts that are necessary for the court to make sense of the case right now. At the same time, don't overload your opening with information the judge just does not need to know yet. That's about as unhelpful as not saying enough. So don't be casual about opening. To give the judge the right amount of information, you need to think carefully in advance about what matters at this stage of the case. Vocally, use short sentences and a deliberate tone. Go at a careful pace. You can watch the judge's pen or keypad to see if you're getting the pace right for the judge. And be consistent about the way you refer to the parties. It can be irritating if you randomly switch between claimant-defendant, applicant-respondent, or even using the parties' names. You can ask the judge for their preference, or better still, anticipate the preference by reference to the documents the judge has already made and which documents have made an impact. When you're opening, don't suggest that your arguments are facts. Your review of the facts of the case should be just that. So any arguments or disputes are distinct from the facts. You can argue your case later. For now, you should simply tell the court what each party is saying and where the dispute is, and present this information neutrally and fairly. You can do this by using a careful and non-pejorative language to say what each party's case or account is. Signposting means telling the judge about the structure you are using and regularly indicating how you're getting on with it. This shows the judge that you are well organized and gives them a sense of your progression through the application. It can also help the judge significantly. In a perfect world, the judge's judgment will adopt the structure of your application without any major structural changes. You should try to convey that you had the judge most in mind when designing your application, and you are, in effect, offering the judge the chance to work with you collaboratively on a structure that will suit you both. To be an effective advocate, you must know the relevant substantive law, and you must be ready and able to advise the judge about it clearly and confidently. And you must never mislead the judge about what the law is. That's completely unacceptable and may lead to disciplinary trouble. So when citing a legal authority, you must do so accurately. Vocally, your tone should be dispassionate, considered, forensic if you like. Any sense of vagueness or imprecision on the law will create anxiety or concern in the judge's mind, not trust. Judges will regularly ask, where do I find that in the documents? If you can answer that quickly and accurately, you'll inspire confidence and build the judge's trust. The judge will see that you are comfortable and familiar with the documents and might reasonably assume that you've analysed the case well. A high-quality chronology can be a very useful tool for a judge who's trying to follow and understand the facts of a case. If you prepared a really great chronology, then the judge learns that you are a dependable and helpful advocate, and the judge may subconsciously feel drawn to rely on you. Vocally, it's good if you can sound very helpful. You might say things like, if it assists the court. That can be found at page 16. But be careful not to overplay how helpful you're being and not to appear too self-satisfied.